So my talk will focus on legal tools to promote vaccination compliance and vaccination rates. And I hope you take four things from this talk. First, I hope you take the fact that the law is an important tool in our toolbox, both for access and for compliance. Second, I want to make the point that the federal government's role in promoting vaccination rates is mostly a supportive and enabling role, not so much a coercive role. Third, I want to make the point that states have broad leeway to use law to increase rates, and we are only using part of the toolbox. And finally, I want to leave the last 2 minutes of my talk to talk about the possibility of government acting to curb misinformation. So where do we start? What we currently have is that the federal government takes several roles in increasing vaccines rates. They're not currently mandating vaccines, and they probably cannot. The Commerce Clause is one of the tools government used to regulate the public health. It probably would not allow a childhood vaccine mandate. Neither the spending power can be used to encourage vaccination mandates by the states, but within limits. It can't be coercive. On the other hand, the federal government has an important role in increasing access. For example, the Vaccine for Children program provides access to vaccine for a lot of families. It has a role in setting the schedule and in messaging about vaccines. It has a role in informed consent. The vaccine information statement that sets out the information about vaccines is a federal document used by others. The main power to regulate towards vaccine compliance is the state's power. States have very broad power to regulate in the area of childhood vaccine because they're drawing on two traditional state powers. First, the police power, the power of states to regulate the public health that's been acknowledged since the 19th century and earlier. And second, on the state's parens patria power, the state's power to protect the vulnerable. The combination of those creates a very strong legal sphere. Most of our regulation so far has been through a school immunization requirement. And one of the points I hope you'll take is that the states have a lot of other tools and it might be a good idea to use them. As I said, states have broad leeway, and the reality is that in over 100 years of contentious jurisprudence about school immunization mandates, no court, state or federal, has ever struck down a school immunization mandate. And I want to spend a few minutes talking about why. When courts look at school immunization mandate or vaccine laws generally, what they see is a framework that involves several important interests and rights. On one hand is the parental autonomy to make decisions in the favor of the child, but there's also the child's right. In a world where vaccine risks are relatively small and vaccine benefit large, there's a good argument that the child's right are to be vaccinated as far as medically possible, as recommended. There's also the individual rights of others who may be infected by an unvaccinated child who contracts a preventable disease. And there's a public health, which, as we know, and as we're experiencing, gives the state extensive power to act to prevent disease from spreading. So when courts look at this, they don't see a balanced picture. They see a picture in which on one hand there's parental autonomy, but on the other hand, there are three very important interests. That's not a closed question. Remember, a parent resisting vaccination law is not only choosing objectively the more risky course for their child. They're not only choosing the bigger risk of not vaccinating for their child, they're also directly putting others at risk. That's not a very strong position to bring into the court. You may ask, what about other rights, such as freedom of religion? We know that freedom of religion is a very strong right in our system. However, for two reasons, it's not a barrier to regulating towards a childhood vaccination. First, under Supreme Court jurisprudence on freedom of religion, a neutral, generally applicable law doesn't have to have a religious exemption. That's currently the law. It may change, but that's where we are right now. School immunization requirements or other vaccine laws are general. They don't target religion, so they don't have to have a religious exemption. Second, even if they were focused on religion, when it comes to children, the power of religious freedom is less because the child is not making the decision. You cannot use religious freedom to put the child directly at risk, and even less to put others at risk. So religious freedom is not a barrier to regulating towards childhood vaccine. That means that states have a very broad set of actions that they can take to increase vaccine rates. Right now, the United States is doing most of its work, states are doing most of the work through school immunization mandates. And I'll go back to that in a few minutes in the next slide. But I want to stop for a moment and remind us that there's a lot of other tools, many of them less coercive than school mandates, which although not as coercive as direct force or as criminal sanctions, impose a very strong sanction limiting access to school. We have other options. For example, many schools provide immunization rates, but very few states require schools to actively provide those rates. Colorado has recently adopted a relatively moderate vaccine law that required schools to send parents the school immunization rates. Requiring schools to inform parents proactively of the immunization rates is not coercive towards the parents, and can you help by helping parents making informed choices. Laws that impose tort liability if non-vaccination causes harm are less directly coercive than school mandates and can be another option that states that don't want to have a very strong mandate can use. Similarly, increasing access, laws that allow minors to be vaccinated are also another possibility that several states are entertaining, and some states already have, to increase vaccine rates without going to a coercive route. So we have a whole set of legal tools. We're focusing on school immunization mandates for good reasons, and I'll get to that in a moment, but we may want to think about broadening our scope. School immunization mandates have been used in the United States at least since the 19th century. Today, every state has some school immunization requirements, but all of them also offer exemptions from them. The vaccines mandates vary by state. This map is out of date. There's 5 states now that only allow medical exemptions from vaccine mandates. That's Mississippi and West Virginia highlighted here, but also California, New York, and Maine. Other states have considered that, but these laws have not yet passed. The rest of the states allow various degree of non-medical exemptions, including religious exemption and personal belief exemption, and the ease of getting them varies. I'm going to not say much more about that because Dr. Mello, who's going to speak later, will address this more in depth. School immunization mandates are common in the United States because they work. They increase vaccination rates and they're legally very sound. And I'll not say more about that again because Dr. Mello will pick this up again. I want to end by speaking a little about the question of whether government can regulate misinformation directly. The starting point for this is that while government has very broad power to say things, and I hope we see more use of that. For example, it would be nice to see stronger government statement on the ways vaccine safety is overseen in the COVID-19 trials. Regulating speech is a lot trickier because the First Amendment limits the ability of government to regulate speech. However, that's not an absolute bar. We do regulate speech constantly, and one area where we regulate is, for example, false advertising. Commercial speech is regulated, and false commercial speech can and is removed. I'll also point out that there are quite a few states who have consumer protection acts that allow dealing with misinformation that also cover nonprofits. So you can, in theory, regulate false information, whether it comes from a commercial group or not. The central leading case in public health and First Amendment about regulating, about prohibiting speech, Central Hudson, says that false or misleading speech is not protected. However, that's not as strong as you'd think. First of all, we do want to be careful in allowing government to directly decide what's true or not. That raises all kinds of risk. And second, misinformation doesn't have to be directly false. it can be misleading in ways that are less blatant. For example, the National Vaccine Information Center, one of our anti-vaccine organizations, posts on every vaccine, there have been X VERS report about this vaccine. By itself, that's true, but without telling the readers that VERS report don't show causation, that anyone can report to VERS and that they don't reflect the vaccine's risk, it can also be misleading, but it's not quite misinformation. So to some degree, government can regulate misinformation by acting against false statements, but there's a limit to that. I'm going to stop here and I look forward to questions.